Welcome back to Youth Express SA, where we bring stories that move, motivate, and make a difference. Today, we're talking to Thiavna Subroyen, who is an attorney at HBG Schindler Law Firm, and she deals with properties and public law. Hi, Shivna.
Hi, how are you?
I'm good. How are you?
Good. Thank you for having me today. I'm looking forward to this time with Youth Express.
I'm looking forward to talking to you too.
Yes.
So, with the rising cost of living, many young professionals are choosing to rent instead of buying. From a legal perspective, what are some of the benefits of signing a formal lease agreement?
Yes. So one of the most obvious things is the fact that renting a property is actually the more affordable option for younger people. So if we look back 20 years ago, when our parents were perhaps in their 20s, it was a time where the housing market was a bit more affordable. If they needed to take out home loans, it was definitely a bit more affordable and the interest was not going to be astronomical. So essentially, when our parents started to enter into the workforce, they would then buy property. Now in this day and age, the housing market is way too expensive and not everyone can meet the requirements for a home loan. And even if people perhaps want to use their credit score to try and apply for property at this age where a lot of us are entering into the workforce, we don't necessarily have any of those accreditations. However, with a lease agreement, you can work according to what your budget is. So as someone who's fresh out of university and perhaps wants to move to perhaps Johannesburg for a job, and if they say, I've only got 8,000 Rand to work with, they can then go onto the market, find someplace that matches their salary, and they can then enter into that. With that as well, you are only in temporary use of the property. So if you only foresee yourself being in perhaps a 6-month lease or perhaps a year, you can then at the end of it make a decision as to whether you intend on renewing your lease or if you intend on terminating it and perhaps going and looking elsewhere. The really nice thing is that because you're not liable for a mortgage bond, and that which is almost a 20-30 year period, you can also elect to cancel your lease. But we will also discuss what that entails for a tenant and a landlord.
Okay, that's very interesting. So, does a lease have to be written to be valid? And is there a standard format for a tenant and landlord that they should follow?
So the actual interesting thing in the law is that a lease is a contract in nature, but it doesn't mean that it has to be written. You can go to a landlord and just convey and make a tacit agreement and say, okay, well, I know that you have this property. I would like to pay 8,000 Rand per month. I intend on using your property for 12 months. Do we have a deal? You can shake on it and that's fine. However, it's not recommended as from a legal point of view because you have not necessarily set out the terms and conditions. Secondly, if there's a dispute that arises and you have to go to the relevant bodies to try and resolve it, it then comes to a he said, she said, and that makes it very difficult to state your case, especially if you are the person that's seeking relief. So we always advise people, and we say just because you're a tenant doesn't mean that you have lesser power than the landlord. If you want a written contract, you can do that. And the wonderful thing is that there's actually no standard form of a contract that you have to follow. We have this thing in the law called a freedom of contract, where you can put anything that you want in your contract, provided that it is not unlawful or goes against anything that is illegal. So obviously you can't say that I'm going to lease a property for the purposes of doing illicit activities. That goes against the law. But there is certain things that we do look at. For example, who are the parties in the lease? Who is the landlord and the tenant? How long are you planning to use the property? Is it a yearly lease? Is it periodic, like monthly? What is the amount you intend on paying per month? Is it 8,000 Rand? Is it subject to an increase every year? Is it inclusive of utilities? Is it exclusive of utilities? Do you have to make any payment towards your municipal account or will the landlord do that? You can look at your notice period. How long do you have to cancel your lease? Or rather, if there is a breach of contract, what do you do? If you as a landlord want to say that you don't want them to have pets on the property because perhaps you live in a complex where they don't allow it, you can have that. You can even have things about the rules of a body corporate. If you say that you can't make excessive noise after a certain time, by all means, you can do that. At the end of the day, it's all about intention to enter into a contract. But as I said, you rather have something down in writing, even if it is with family members and friends and it is personal. Believe me, the worst cases as an attorney is dealing with family disputes. So if you can avoid that by having something in writing, you are protecting yourself not only as the tenant, but also as the landlord.
So it's safer.
It's safer. We will always advise to have a safety net of a written contract.
Okay. So we always hear about security deposits when renting. What exactly is a security deposit and what is its purpose?
Okay, so a security deposit is an amount which you pay to the landlord. As the word says, it's security. For the landlord, it is there to ensure that in the event that a tenant uses the property and perhaps there's damage to the property, they can then use that to perhaps cover their costs for perhaps repairing or restoring the property, and to ensure that if, for example, also if a tenant decides that they're going to default on payment, they can use that money to then make up and restore that breach of contract. So essentially, it's actually there just to ensure that the landlord is in a safer position in protecting their property. But also, it also prevents the tenant from perhaps misusing the property, or it gives them the initiative to keep the property in working condition and neat and tidy. And also, as the tenant, you are entitled to receive that deposit back when you terminate or cancel your contract. This is in the event where if there's actually nothing wrong with the property, you've done everything you could to look after it, and you've decided you're done, you're ready to relocate to another place, your landlord has to give you that security deposit within 14 days of the conclusion of the contract. If there's a situation where there has been damage to the property and he has to make the necessary deductions upon his inspection, then he must ensure that whatever has been left over from his deductions is paid within 20 business days to the tenant. So it's not just a benefit to the landlord, it's also tenant getting money back into their account. But also, a landlord must put that deposit into an interest-bearing account where it essentially grows money in that time that you are in their property. And if they don't, then you as the tenant can go and approach the rental housing tribunal for relief. But that we will talk about at a later stage.
So can a landlord just show up at the property unannounced, or are there rules about when and how they can enter while the tenant is living there?
Absolutely not. Even if a landlord has to come onto the property to attend to repairs, you can't just simply come at any time when it suits you as the landlord. You have to give your tenant notice, and it can be something as simple as a WhatsApp message. You can say even 24, 48 hours before. You can just notify the tenant, and the tenant can make the necessary arrangements, but it's usually the case if a landlord has a spare key on them. But even if they do have a spare key, they cannot just simply enter the property whether you're there or not. That is deemed to be a breach of contract, because you as the landlord have a duty to respect your tenant's privacy. The only time you can go onto the property without your tenant's permission is in the event of an emergency. Say, for example, there's actually flooding on the property and the tenant is nowhere to be found. You can go because that is deemed to be an emergency situation. But even if your tenant has intended to cancel their contract and you are looking for a new tenant to come and look at the property, again, you cannot just simply allow your estate agent and the new applicant to just come onto the property. Again, you have to give reasonable notice to your tenant as to you intending to come onto the property for what purpose.
Okay, that makes a lot of sense. And what happens if a tenant wants to improve or upgrade something in the property, like installing shelves or painting? Is that allowed, and who usually pays for it?
Well, firstly, we always advise people who enter into leases is to first check what the rules are of a body corporate, because there is obviously what we call the exclusive common property, such as your pool areas, your gardens, all of that which is maintained by the body corporate. But then you also have your own private property, which you, for example, you can go and add improvements to it. We always advise that you add in a clause to your written contract to say, if you can, as a tenant, improve the property. By all means, if you want to perhaps add a lick of paint because perhaps the walls are not looking too beautiful, we always advise that you get the consent of the landlord, because at the end of the day, it is his property. And if he says no, then you can't do it because it's breach of contract. And generally, you can actually say, look, if I intend on making improvements to the property, can we please deduct the certain amount from my rent that I pay to you because I'm adding and enriching your property? Or you can say, okay, I'm going to pay this, but then you must add this amount to my security deposit that's paid at the end of the day. Or you can say, look, landlord, I need to make this improvement to the property because it's necessary. Perhaps there is a crack in the wall that needs attendance to. You can say, okay, well, look, I'm not in a position to actually pay for this. Can you pay for it? And the landlord can say, sure. But if he doesn't, then you can just identify it as a snag that is not caused by you. So that when it comes to inspecting the property, when you do intend on leaving it, you are not held liable for that crack because you did notify your landlord. But also there is a difference between wear and tear versus damage to the property. Wear and tear essentially is day-to-day use of the property. Say, for example, there's a carpet that's been provided by the landlord and you walk on it and there's perhaps stainage. That's general wear and tear. A landlord can never deduct your deposit because of wear and tear to the property. But if there's damage caused by the property, in other words, you have shortened the lifespan of something, you can be held liable. For example, if you decide that you're going to punch into the window and you're going to break the glass, a landlord can hold you liable for that. So those are two very important items. And if you feel like you can't come to an agreement as to wear and tear versus damage, by all means, take it to the rental household tribunal.
Okay, thank you also for clarifying the wear and tear, because that was my next question. So when it comes to utilities like electricity and water, who is legally responsible for those bills? Is it the landlord or the tenant?
So in that instance, we obviously know that in the time that the tenant is in the property, he's technically using the water, the electricity, the Wi-Fi, but it also depends on how you formulate your contract. If you decide that you are taking this contract because it includes 8,000 Rand, includes utilities, then that will usually then be that what you pay to the landlord is inclusive of that and he pays the municipal account or he pays for the water. There's also instances where you're paying just rent and it excludes water and lights. You may have to pay that separately to the landlord. And that may be that he will provide you with an invoice every month and say, okay, well, you owe us perhaps 200 Rand for the municipal invoice. Please also pay that on top of your 8,000 Rand. But given that I also deal with municipal law, we usually advise clients that if you're worried about utilities and perhaps you want to get a prepaid system into place, you can actually approach, for example, the city of Joburg and ask for a separate account to be made for the property so that the tenant themselves gets the invoices directly to them and they can pay for it. But also, if they decide that they're going to default on the municipal utilities, that's on their account, not yours. And you can also say that in your contract that you are responsible for utilities. If you do not pay, the city or whoever it is may come after you for those costs.
Okay, thank you. And what's the real purpose of doing inspections before and after a lease? And should tenants be present during these inspections?
So inspections, we refer to entry inspections and exit inspections. That is for the benefit of not only the landlord, but more importantly for the tenant. An entry inspection is for you as the tenant to enter the property before you have occupied it, to ensure that everything is in working condition. I always advise, especially youngsters, do a snag list. You take a list, you look at the property before you go and occupy it, to make a list of things that were there before you decided to sign this contract. So that when it comes to the end of your lease, you're not held responsible for that. Even if it's a cracked tile, even if the stove oven is not working, make a note of it. It's also for you to point out these snags to the landlord so that he's accountable for that. It's also for you just to make sure that everything's in working condition, and also, most importantly, that the property that's been advertised matches the description. Obviously, if you intended to move into a 2-bedroom apartment and you go there and in fact it's only a 1-bedroom, that's misrepresentation by the landlord, and that's not what you signed up for. Also, as the landlord, you have to ensure that the property is also available for your tenant. You can't just simply agree that on the 1st of August your tenant can move in, but in fact you still have a previous tenant there. It doesn't make sense. Also, to ensure that for you as well, the property is in usable working condition for your new tenant. So that's the entry inspection. The exit inspection also has importance for both the landlord and the tenant to be present. It's also, once again, to see that even after you've used the property, it is still in working condition to be returned back to the landlord. Obviously, as a landlord, if you're coming in and there's cigarette burns on your carpets, your curtains are in absolute disarray, your walls have holes in them because your tenant punched them, I mean, that's now your property being depreciated because of the misuse of it. So again, it's for you to also go through your snag list and say, okay, well, that was not there when we looked at the property. This has caused damage to my property. I now have to repair it before I give it to someone else. So this also determines whether you will get your security deposit back as the tenant or as the landlord if you have to now make deductions because there has been damage to your property. That is why inspections are so important, both in the beginning process and the end process.
Okay, so with the ingoing inspection, the tenant doesn't need to be...
We advise that they do go. Yes. We advise tenants to go in the ingoing inspection and also the outgoing inspection.
Okay.
That's also to protect their interests in the event that the landlord wants to perhaps be malicious and wants a bit of money out of that, because the reality is that not every landlord is perfect.
True. Okay. And what are the main responsibilities or legal duties of a tenant during their lease period?
The most important thing is that you upkeep the property, you use it for its purpose, you make your monthly payments to your landlord. If you don't, that's immediately breach of contract. You do what you can to keep it in the same condition that was given to you, and even when you leave, that it's kept in that same condition. You also ensure that you respect the property as if it is yours in that time. And it's also advisable that if you can make improvements to the property and got the funds to do that, by all means, do that. But the first rule of thumb is always, when in doubt, get permission or get notification from your landlord should you want to do anything to the property. But also, if you feel that there's something that's, for example, a crack in the wall that has taken place, and you don't notify your landlord, that can also be a breach of contract. So you also have a duty to notify when there's a burst pipe or a crack in the wall or something that could be a fire hazard to your landlord.
Okay, so essentially communication is key.
Communication is key, and I will say that for everything, whether it's your relationships, your friendships, or even your landlord and you. Open communication is vital just to keep a contract in place.
I agree with that statement. And if a tenant wants to leave the property before the lease ends, how can they legally cancel the lease without getting into trouble?
So life happens, right? I can say from personal experience that I was in Cape Town for a bit and I got an opportunity to then come back to Johannesburg, and my lease unfortunately had to be cancelled. And what the general rule is that if you intend on cancelling your lease before the end of term, you have a duty to give notice to the landlord within 20 business days. That gives the landlord also an opportunity to also make the arrangements to then put the property back on the market. If it's, for example, a monthly lease, we advise a month prior. If it's a weekly lease, you need at least 2 weeks' notice. You can't just simply cancel and not have any consequences. Now, again, it could be on a case-to-case basis where also the security deposit may be there to assist in the event you want to cancel your lease. There may be a penalty that may be included in the contract. It may be a fixed fee. For example, should you cancel your contract, you'll be charged a 3K penalty fee. I've also seen cases where it is circumstantial, where the landlord will look at how long you were living there, whether you made your payments on time, were there any damages or snags on the property when you lived there, and they can have a discretion to say, okay, well, I'm not going to charge you a penalty fee, you can have your deposit. So generally it is observed that you can foresee a penalty fee coming through, but that's also for a landlord to recoup their losses because you've now cut short your lease, and now they have to incur costs to appoint an estate agent and to obviously advertise the property.
Thank you so much for the amount of knowledge that you have shared with us today, and we look forward to having you on our show again.
Thank you for having me.
Thank you.